Wednesday night, Eyewitness News reporter Shelby Pay brought us Oneida County District Attorney Scott McNamara's thoughts on a recent study regarding New York State's discovery law, a law that gives the defense the right to get additional evidence. Tonight, Shelby brings us more from McNamara on how the discovery law impacts other state legislation.
Leandra's Law, also known as the Child Passenger Protection Act, was enacted back in 2009. The law makes it an automatic felony after only the first offense to drive under the influence with a child under the age of 16 in the car. But what DA Scott McNamara is trying to say is, while this law is important, the discovery law component that is tied to it is making it more difficult for prosecutors to do their jobs.
For instance, when you have a Leandra's Law case, we have to prove the age of the children in the car, even though it's really apparent that the kid is under the, like say for example, you have a baby in a car seat. One could assume that it's pretty easy to and most lay people would say, oh, that's easy to prove. No, we got to get a birth certificate for that child. So how do we prove that child? Well, we got to figure out where the child was born. Once again, we don't have a crystal ball. We don't know, was the child born in Utica, was the child born in Rome, or was the child born in Florida? We don't know. That takes time.
He goes on to explain that if the discovery law stated to have all related evidence submitted before trial, that would be realistic. But the way it's written now is to the time of arraignment.
When I said before, if you make it tied to the time of trial, well, by the time we're ready to go to trial, we're going to have all those things or we can't win the trial. But we're surely not going to have a birth certificate. Like in this case, if it's a felony, so we have 6 months to get it. But if it's a misdemeanor, if that charge was only a misdemeanor, we don't have 6 months. We got 90 days, and if we don't get it in 90 days, game, set, match, it's over. We lose. Lost on a technicality. And then people get mad and say, well, they got off on a technicality. Well, I didn't make the technicalities. And this law is just, it is a field of landmines of just technicalities.
He adds that, again, he doesn't want the discovery law completely thrown out. He just wants to fine-tune it in a way that won't affect the prosecution.
So why don't we do this? Why don't we go back to the drawing board and say, what are the quirky little things that are denying our victims justice? Related should be changed to material to the prosecution of the case. You know, the time that it has to be turned over. Not every single case within 45 days of arraignment, or the person's in jail, it's even a shorter period of time. Tie it to the time that the trial is going to take place. And then we're not doing discovery on every single case.
As McNamara said, he didn't have a hand in passing the discovery law legislation, but the New York State Assembly and State Senate did. So I'll be following up with Assemblywoman Buttonshaw and Senator Griffo over the next few weeks to hear what they have to say about the discovery law and how it can impact other pieces of state legislation. Reporting in Oneida County, I'm Shelby Pay, Eyewitness News.
Be sure